A federal judge rules that drag show bans in Tennessee are unconstitutional. We're going to go through the full opinion. We're going to take a look at the background from the Hill before we read through what the judge said. This was a new ruling out of Tennessee that says that banning drag shows is unconstitutional, saying it violates free speech protections. The judge's name is Thomas Parker. He said in a ruling that it's unconstitutionally vague and substantially overbroad to ban adult cabaret performances. The law says that an adult cabaret performance is unlawful if it happens on public property or in a location where the performance could be viewed by a person who's not an adult. It defines the performance as one that is harmful to minors, and that includes topless dancers, exotic dancers, strippers, and male and female impersonators. Parker had issued, the judge, a preliminary injunction at the end of March to block the law from taking effect. He agreed with Friends of George, a Memphis-based theater group that produces these performances, saying that this law could apply just about anywhere. And they say that it would violate our free speech rights and put members at risk of felony charges for shows that it's held for years. The group said the law was overly broad because it applies to minors of all ages and anywhere that a minor could be. Parker agreed with the ruling, with that argument. Here's the opinion from the judge. This came out of the Western District of Tennessee. It is 70 pages. We'll hit the highlights. Filed in the case of Friends of George's Inc. versus Stephen Mulroy in his capacity as the DA out of Tennessee. The judge writes, "Freedom of speech is not just about speech. It's about the right to debate with fellow citizens on self-government, to discover the truth in the marketplace of ideas and to express one's identity, and to realize self-fulfillment in a free society. That freedom is of first importance to many Americans in the U.S. Supreme Court, such that the U.S. Supreme Court has relaxed procedural requirements for citizens to vindicate their rights to freedom of speech, while making the government less likely to regulate it. This case is about one such regulation. The judge says the Tennessee Assembly enacted a statute that criminalizes the performance of adult cabaret entertainment, which is any location where an adult cabaret entertainment could be viewed by a person who is not an adult. Plaintiff, Friends of George, sued, saying the statute is unconstitutional. It impinges on our free speech. After a hearing, the court issued a restraining order. And now, after considering the briefs, this court finds that despite Tennessee's compelling interest in protecting the psychological and physical well-being of children, the Adult Entertainment Act is unconstitutional because it restricts free speech and permanently enjoins the government from enforcing the unconstitutional statute. Here are the undisputed facts. They say Tennessee passed the law. Nobody disagrees with that. Here's what the law says. Adult cabaret entertainment. Entertainment is this. Section 2 of the law says where on property. Harmful to minors is the standard. What is the standard in the law? Harmful to minors means the quality of any description or representation in whatever form of nudity, sexual excitement, conduct, excess violence, sadomasochistic abuse, or any of those things, when it would be found by the average person to appeal predominantly to the prurient, shameful, and morbid interests of minors, or if it's patently offensive to the prevailing standards of the adult community as a whole, and if taken as a whole, lacks serious literary, artistic, and political and scientific values for minors. So this is just kind of standard constitutional free speech language about categorizing speech and what that conduct must meet in order to qualify. So if it's something that entirely lacks any other justification for it, if it's not literature, if it's not artistic, if it's not political value, if it's not scientific value, it's not going to meet this standard, and therefore it's not protected. They say that plaintiff, Friends of George's, is a registered nonprofit, and they produce drag-centric performances, comedy sketches, and plays. They sued. They say this is unconstitutional. In response, the city responded, and the court held a hearing. And here's what the judge says. The court makes findings of fact. They say Miss Vanessa Rodley testified as a board member, and she says that their group's mission is to raise money for LGBTQ plus nonprofits. And they seek to provide a space for some non-adults to enjoy drag. They say they want to provide a space for people to enjoy drag shows. They say even though plaintiffs' members believe that there is, quote, nothing wrong with drag shows in age-restricted venues like bars, plaintiff seeks to provide a space for some non-adults to enjoy drag outside of stigmatized age-restricted venues. Okay? Drag features male and female impersonators, but also non-binary persons. Drag performers in plaintiff shows could be males impersonating females or females impersonating females. Plaintiffs produces its own original artwork. Its members act and write and do all the things. Rodley is not a performer. Almost all of their performances are in a theater with no age restrictions. Plaintiff also produces performances at other venues, but has no control over the age restrictions there. The performances can be sexual, but the performers try not to get, quote, too risque. Okay. They try to stick around the PG-13 area. At the trial, plaintiff played videos of its production. The court viewed the videos. Defendant also submitted video clips of the holiday program, which the court also watched. The first production describes sexual acts, including intercourse and masturbation. The court finds that the conduct of the performers could be interpreted as violating the act. The second production also could be interpreted as violating the act. These are videos typical of what they do. They're concerned that they could be charged with felonies for producing these things. She testified that she witnessed a noticeable decline in the festivals because of these laws. They secured 90% of its budget, and now their budgets are down. The parties now cite the legislative history, meaning they're going back and listening to the people who actually passed the law, and they're talking about the legislators. Senator Johnson, he said co-sponsored the bill. Here is the summary. The court finds that these are the court's conclusions. They say there are several issues with this case that overlap. The court will take issues one at a time, reiterating some of its factual findings when appropriate and stating its legal conclusions as necessary. Here's the summary. They say that the plaintiff, the drag show company, is arguing that the AEA is constitutionally vague because it applies to expressive conduct that is harmful to minor of all ages. It is both a content and a viewpoint-based restriction, and that it's overbroad because it applies anywhere a minor could be present. Defendant makes many arguments to save the statute, including saying it's not unconstitutionally vague, only expressive conduct that is harmful to a reasonable 17-year-old. They say it is content neutral because it's predominantly concerned with the secondary effects of the conduct, and it's not overbroad because it only applies to public property and private venues without an age restriction. Now, the court concludes that they've proven their Article 3 standing. They say that this standard requires strict scrutiny because they say it is content and viewpoint-based restrictions. It's different from a different category of restrictions. Another type of restriction on speech, the one that we don't really look at with as much scrutiny, meaning we allow it to happen more regularly, are restrictions on speech, but they're called time, manner, and place restrictions. We hear these all the time. You can protest, you just can't protest at that time, at that location, or using that bullhorn. This is different. This is saying you can't actually say that thing or do that thing. It's not that you can't do it in a certain location or those things. The judge is interpreting it saying that this is a content and viewpoint-based restriction. This is stopping them drag showing, which is different than saying you can't do it here, or you can't do it there, you can't do it at this time. It says the AEA was passed for the impermissible purpose of chilling constitutionally protected speech, and the secondary effects doctrine does not save it from that strict scrutiny review. And a quick constitutional backbone discussion on this. There are several different levels of scrutiny. The government, when they pass a law and it implicates a right or it implicates something that happens to you, we say, can the government do that? You know, are they allowed to do this? I thought we had rights. Can they do that to us? So we apply it through different filters. We call them different standards of review. And there's a base layer one that's called rational basis. If the government is not impinging on your free speech or your constitutional rights or any of your natural rights, then they're allowed to do that. If there's a rational basis for them to do that because it furthers a legitimate government interest, they can basically do it. When it starts to impinge on your rights, then we elevate, we say, no, you don't get to just do whatever you want. We're going to elevate it. We're going to put it through intermediate scrutiny or strict scrutiny. And then once it's at that highest level, it's kind of like beyond a reasonable doubt. If the government is going to pass that law, it has to be absolutely necessary for the government to do it because it's impinging on those rights. So the judge is telling them, hey, like this sucks for you guys, but it is going to be the highest level. It's going to be the strict scrutiny review here. The court concludes that the AEA fails strict scrutiny review. Tennessee does have a compelling interest in protecting minors, but the defendant has not met this burden by showing that the AEA is narrowly tailored and the least restrictive means to advance those interests. And that's the standard. When we get in criminal law and we talk about beyond a reasonable doubt, this is the standard for strict scrutiny. The law has to be absolutely narrowly tailored to only hit the constitutional protections, to only override that, and it has to be the absolute least restrictive means possible to achieve that outcome. They're saying this law doesn't do that. The court concludes that the AEA is both unconstitutionally vague and substantially overbroad. The harmful to minor standard applies to minors of all ages, so it fails to provide fair notice, and it encourages discriminatory enforcement. The AEA is substantially overbroad because it applies to public property anywhere a minor could be present. And finally, the court concludes that the constitutional avoidance canon does not apply to the constitutional defects of the law. Their proposed narrowing constructions are unmoored from the text and unsupported, if not contravened, by legislative history, which the defendant asks the court to consider. Acceptance of the defendant's proposed narrowing would require the court to rewrite the statute and to violate the principle of separation of powers. And so if we fast forward all the way through to the conclusion, let's see what the judge says after some heavy analysis. And they detail the following. First, they say that the act in itself is unconstitutional. It's a restriction on free speech. The court concludes that it violates the First Amendment as incorporated to Tennessee by the 14th. They're also seeking injunctive relief to stop the enforcement of this, and the judge grants that. The court enjoins Stephen Mulroy from enforcing this in Tennessee. It says, let there be no mistake about this court's recognition. Tennessee does have a compelling government interest to protect minors. Scores of concerned Tennesseans asked this court to uphold the AEA because their state supposedly enacted it to protect their children. It says Tennesseans deserve to know that their state's defense of the AEA primarily involved a request for the court to alter the statute by changing the meaning of minors to be a reasonable 17-year-old minor. In other words, while its citizens believe this powerful law would protect all children, the state's lawyers told this court this law will only protect 17-year-olds. This is one of the only ways in which Tennessee asked this court to rewrite the law. To rewrite this law would not only be a violation of separation of powers, but it would also offer perverse incentives for legislatures and legislators to continue their troubling trend of abdicating their responsibility in exercising their judgment. The legislature can pass the laws that their communities demand, but what mandates under the Constitution cannot be infringed, and therefore the court declares the Adult Entertainment Act is unconstitutional and enjoins Stephen Mulroy from enforcing it. Signed by Judge Thomas L. Parker, which is just amazing. So in Tennessee, they're going to have to redraft some statutes if they want this type of thing to pass, because as written, the judge is not finding any way to rewrite it for them. So they're going to have to go back to the drawing board and try again. In the meantime, drag shows in Tennessee can carry on, not prohibited under the AEA, according to this judge, until this case goes up on appeal or until the statute decides to remedy the law and try again.